So today we got some great news for women, females, and supporters of reproductive rights across this country from one of the least likely states imaginable. So the good news that we got today for pro-choicers everywhere came from, of all places, South Carolina, right? One of the deepest, reddest states in this country. Actually, before we dive into it, let's take a look at the structure just for context here, right? So they have a Republican governor, but their state legislature is profoundly red. It's bicameral like the United States Congress. It's got a state Senate and a state House of Representatives. In the state Senate, Republicans have twice as many members as Democrats, 30 Republicans to 16 Democrats, right? And in the House, it's basically the same thing, 88 Republicans to 36 Democrats, right? That's the uphill battle that Democrats, liberals, the left, sane people in general, that's the uphill battle they have to climb in South Carolina. And yet, the South Carolina State Supreme Court struck down a deeply regressive, prohibitive, and extremely cruel law, which banned abortions at 6 weeks. And this is a relatively new story, so details are coming out. But the South Carolina State Supreme Court on Thursday struck down the state's 6-week abortion ban, asserting that such a law violates South Carolina's Constitution, which guarantees its citizens a right to privacy. And that was the basis by which 3 of these South Carolina State Supreme Court justices overruled the other 2 and struck down the law. And before we get into their rationale and everything, it's probably beneficial to discuss what that law was, even though, as of now, it's no longer in effect. So, for context, you'll remember that last year, in late June, the United States Supreme Court, the highest court in the land, they struck down the federal protections for abortion guaranteed by Roe v. Wade and Planned Parenthood versus Casey. I think it was like June 24th or something like that. They struck it down. And when that happened, in many conservative states, many Republican states, trigger laws went into effect that instantly banned abortion at certain levels. 6 weeks was very common for what they call fetal heartbeat bills, right? That was the threshold. Given that a heartbeat can be detected at 6 weeks, that was the arbitrary conservative benchmark for abortion bans. And South Carolina was one of the states that instantly triggered those laws. So 3 days after the Dobbs decision, South Carolina's Attorney General said that the heartbeat law is now in effect because Dobbs cleared the way. As far as the law's provisions, it outlawed abortions after a fetal heartbeat is detected, about 6 weeks, and required the mother to view an ultrasound of the fetus, hear the heartbeat of the fetus, and receive additional information about the child's development. Okay, that's emotional terrorism, right? There's this really cruel and dishonest conservative meme that those who seek abortions do so very cavalierly, right? Very casually, like they've just they're bored. They've went through their Netflix queue. There's nothing on Amazon Prime, so what are you going to do? Well, I guess I'm going to go out and have an abortion. It's just BS. It's crap. It's flagrantly dishonest, and it's used to tar and feather people across this country who want to exercise control over their body and their reproductive rights. You ask any person who's availed themselves of their right to have an abortion, because there have been conservative people who've had abortions, there have been liberal people who've had abortions, but you ask most people, the vast and overwhelming majority, at least in my experience, of friends and family who I know have had it, they'll tell you it was a profoundly troubling and very sobering action. Even if they would do it again, right, in the sense that even if they know it was the right decision, even if they still believe or have believed afterwards that it's a right that should be afforded to all Americans, nobody celebrates it, right, outside of some fringe, obscure examples in a country of 330 million. So it's just this is emotional terrorism. There's no need for this, right? Somebody who's coming to have an abortion has probably thought very carefully about it, particularly when in many cases, there are certain medical hurdles along the way. But anyway, making a woman view an or a mother view an ultrasound, hear the heartbeat, it's just emotional terrorism. It's very cruel. It does say that the law allowed for exceptions for rape or incest if the fetus was fewer than 20 weeks old. How generous. That a potential mother would not have to carry her the fruits of her sexual assault, her violation, her rape, to term if it was under 20 weeks. It's profoundly cruel. So anyway, that was the law. And that was the law that was struck down. And again, the basis for it, according to the court's majority, is we hold that our state constitutional right to privacy extends to a woman's decision to have an abortion. Now, they do acknowledge that the state unquestionably has the authority to limit that right, but any such limitation must be reasonable, and it must be meaningful in that the time frames imposed must afford a woman sufficient time to determine she's pregnant and to take reasonable steps to terminate that pregnancy. 6 weeks is, quite simply, not a reasonable period of time for these two things to occur, and therefore the act violates our state's constitution prohibition against unreasonable invasions of privacy, and that was the basis by which it was struck down. Now, obviously, this is going to piss off pro-lifers, and which, by the way, what a misnomer, right? To so many Republicans and to so many pro-life advocates, life apparently ends at birth to them. They care so much about a fetus and forcing women to carry fetuses to term. And then afterwards, they don't support any sort of, social safety nets, any sort of robust or comprehensive sex education, easy or free access to contraception, or guaranteeing the right to access contraception, right? So it's just, it is quite simply a desire to force women to carry fetuses to term against their will. That's really fundamentally what this law and others are about. Now, if they were paired with aggressive and comprehensive sex education, making it super easy and affordable to access birth control, or making it free would be even better, and neonatal health care and all these things, then I could at least in theory buy the argument that conservatives who are pushing this law are doing so in good faith, and they do care about the mother, they do care about the fetus after it leaves the birth canal, and therefore they are genuinely pro-life. But that's not the case, and it's very rarely the case. So they're not pro-life, they're just pro-forced birth. But anyway, it's going to piss that group of people off, both in South Carolina and out. As a matter of fact, the Republican House Speaker said Thursday that the state Supreme Court's ruling fails to respect the separation of powers. The United States Supreme Court, through their Dobbs decision this summer, handed the issue of abortion back to state legislatures. Unfortunately, the South Carolina Supreme Court followed the path of the U.S. Supreme Court in Roe v. Wade by creating a constitutional right to an abortion where none exists. Today's decision fails to respect the concept of separation of powers and strips the people of the state from having a say in a decision. Instead, South Carolina is left with a decision that is not reflective of the state's political process or will. Well, and there again, I just find this interesting because as far as I know, even in South Carolina, the state Supreme Court has the right of judicial review, and they have the right to strike down laws that are unconstitutional in terms of their state constitution. They have every right to do that. And it's so funny how conservatives and Republicans in certain decisions will say, hey, look, we're not a democracy. We're not all about majority views. We're about laws and rules and law and order. And yet when the interpretation of those laws and the law and order goes a way that they don't like, then they appeal to popular will, right? Because then they'll appeal to majority rule. This idea, well, look, this is a decision that the majority of our representatives who are elected by a majority of our constituents, this is what they want. How dare the court intercede? So it's standard Republican and conservative hypocrisy, and we'll see where it goes. They may try to issue a challenge back to a higher court. I'm sure this is not the end of the process. But in the meantime, this is a victory for, again, supporters of reproductive rights everywhere. And it follows along with what we saw in the referendum last year in Kansas. So people everywhere who are pro-choice should celebrate this. And hopefully this is a sign of things to come in other conservative states as well.